Chapter 2. The Master's Relation to Vessel and Cargo. Revenue Duties and Obligations. List of Crew. Certificate. Sea Letter. Passport. List of Passengers. Manifest. Sea Stores. Unloading. Post Office. Report. Citizenship. Coasting License. Power to sell and hypothecate. Keeping and delivering cargo. Deviation. Collision. Pilot. Wages and advances. Revenue duties and obligations. The master of every vessel bound on a foreign voyage, before clearance, must give to the collector of the customs a list of the crew, specifying their names, places of birth, and residence, and containing a description of their persons, whereupon he is entitled to a certified copy of the same from the collector. This copy he must deliver, under a penalty of $400, to the first boarding officer upon his arrival in the United States, and produce the persons named therein, unless the same have been discharged in a foreign country, with the consent of the counsel or other commercial agent thereto certified in writing under his hand and official seal, or by showing that they have died or absconded, or been impressed into foreign service. Act 1803, Chapter 62, Section 1. The duplicate list of the crew shall be a fair copy, in one uniform handwriting, without erasure or interlineation. Act 1840, Chapter 28, Section 1. The owners must also obtain from the collector of the customs a certified copy of the shipping articles. This must be produced by the master before any counsel or commercial agent who may demand it, and all erasures in it or writings in a different hand shall be deemed fraudulent, unless satisfactorily explained. Act 1840, Chapter 28, Section 1. The master of every vessel of the United States, on arriving at a foreign port, must deposit with the counsel or other commercial agent his certificate of registry, sea letter, and passport, if he have one, under a penalty of $500. The counsel returns them to him upon his obtaining a clearance. Act 1803, Chapter 62, Section 2. Upon arriving in the United States, the master must report to the collector a list of passengers, specifying their names, age, sex, occupation, the country of which they are citizens, and that in which they intend to reside. This is under a penalty of $500. Act 1819, Chapter 170, Section 4. Vessels arriving from foreign ports must unlade and deliver their cargoes between sunrise and sunset, unless by special permission of the collector of the port. In making out manifests of cargoes, the master must specify what articles are to be deemed sea stores, and declare the same upon oath. If the collector deems the amount excessive, he may charge them with a duty. If the cargo is found to exceed the manifest, the excess is forfeited to the government, and the master is liable to pay treble the amount. Act 1799, Chapter 128, Section 45. If the master land any of the sea stores without first obtaining a permit, such stores are forfeited, and the master becomes liable to pay treble the value of them. Act 1799, Chapter 128. Section 45. It is the duty of the master, coming from a foreign port, to have a manifest of cargo, and a copy of the same made out and ready for delivery to any officer of the customs who may board the vessel within 4 leagues of the coast. Act 1799, Chapter 128, Section 23. Unless this manifest is produced, no merchandise can be unloaded from the vessel. The manifest shall specify the port where the merchandise was received, the port to which it is consigned, the name, built, and descriptions of the vessel, with the name of the master and owner, the marks and numbers of each package of goods, with the name of the consignee, and also the names of the passengers with their baggage, and the account of all remaining sea stores. Act 1819, Chapter 170, Section 4. If any goods are unladed within 4 leagues of the coast, or within the limits of any district, without authority from the proper officer, except in case of accident or necessity, which must be strictly proved, such goods are forfeited, and the master and mate incur, respectively, a penalty of $1,000 for each offense. Act 1799, Chapter 128, Section 27. If the master refuses to exhibit his manifest and deliver a copy of the same to the boarding officer, or to inform him of the true destination of the vessel, he incurs a penalty of $500 for each offense. Act 1799, Chapter 128, Section 26. The master must deposit all his letters in the post office before entering his cargo, and if he shall break bulk before depositing his letters, he forfeits $100 for each offense. Act 1825, Chapter 275, Section 17. If any merchandise is imported into the United States not contained in the manifest, the master of the vessel forfeits a sum equal to the value of such merchandise. And if any of it belongs to, or is consigned to the master, or to any officer or seaman on board, it becomes forfeited, unless it shall be made to appear that the omission occurred by accident or mistake. Act 1799, Chapter 128, Section 24. The master of a vessel arriving from a foreign port must report himself to the collector within 24 hours, and within 48 hours he must make a further and more particular report in writing, under penalty of $100, and if he shall attempt to leave the port without entry, he forfeits $400. Act 1799, Chapter 128, Section 30. If any articles reported in the manifest are not found on board, the master forfeits $500, unless it shall be made to appear that the same was caused by accident or mistake. The master of every vessel bound on a foreign voyage must deliver a manifest of cargo to the collector, and obtain a clearance, under penalty of $500. Act 1799, Chapter 128, Section 3. The master of every vessel enrolled and licensed in the coasting trade must be a citizen of the United States, and if the vessel trades to any other than an adjoining state, 3/4 of the crew must be citizens. If the master of a coasting vessel is changed, such change must be reported to the collector of the port where the change is made. Act 1793, Chapter 52, Section 12. The master of every coasting vessel must deliver up his license within 3 days after it expired, or if the vessel was then at sea, within 3 days after her first arrival thereafter, under a penalty of $50. The master of a coasting vessel departing from one great district to another must deliver to the collector duplicate manifests of all the cargo on board, under penalty of $50. And within 48 hours after his arrival at the port of delivery, and before breaking bulk, he must deliver to the collector the manifest certified to by the collector of the former port, under penalty of $100. Act 1793, Chapter 52, Section 17. If the vessel shall at any time be found without a manifest on board, the master forfeits $20, and if he refuses to inform the officer of his last port of departure, he forfeits $100. Act 1793, Chapter 52, Section 18. Revenue duties and obligations in England. By the 3 and 4 William IV, Chapter 52, entitled An Act for the General Regulation of the Customs, it is enacted, that no goods shall be shipped or waterborne, to be shipped on board any ship, in any port or place in the United Kingdom, or in the Isle of Man, to be carried beyond seas, before due entry outwards of such ship, and due entry of such goods shall be made, and cocket granted, nor before such goods shall be duly cleared for shipment in manner thereinafter directed, and that no stores shall be shipped for the use of such ship, except such as are borne on the victualling bill of such ship under pain of forfeiture. Section 61. That no ship on board of which any goods or stores shall have been shipped for parts beyond the seas shall depart from such port until such ship shall have been duly cleared outwards for her intended voyage, under pain of forfeiture by the master of £100. Section 62. It may be useful to state in this place in what this duly clearing of a ship consists. The master of every outward-bound ship shall, upon application to an officer, called the searcher, receive a victualling bill for the shipment of such stores as he may require, and as shall be allowed by the collector and controller for the use of the ship according to the voyage upon which she is about to depart, and no articles taken on board shall be deemed to be stores, except such as shall be borne on such victualling bill. Section 63. He shall also, before any goods be taken on board, deliver to the collector or controller a certificate from the proper officer of the clearance inwards or coastwise of such ship of her last voyage, specifying what goods, if any, have been reported inwards for exportation, and also deliver to the collector or controller an account, signed by the master or his agent, of the entry outwards of such ship for her intended voyage, setting forth the name and tonnage of the ship, the name of the place to which she belongs if British, or of her country if foreign, the name of the master, of the place for which she is bound, and of the place in such port at which she is to take in her lading for the voyage. The particulars of such account shall be written and arranged in such form and manner as the collector and controller shall require, and such account shall be the entry outwards of such ship, and shall be entered in a book to be kept by the collector for the information of all persons interested. And if any goods be taken on board any ship before she shall have been entered outwards, the master shall forfeit £100. If, however, it becomes necessary to lade any heavy goods before the whole of the inward cargo is discharged, it shall be lawful for the collector and controller to issue what is called a stiffening order for that purpose. Section 64. Every person entering outward goods for export beyond the seas shall deliver to the collector or controller a bill of the entry thereof, fairly written, or fairly written in part, and fairly printed in part. 1 and 2 Victoria, chapter 113, in words at length, expressing the name of the ship and of the master, and of the place to which the goods are to be exported, and of the person in whose name the goods are to be entered, and the quantities and proper denomination or descriptions of the several sorts of goods, and shall pay down any duties which may be due upon the exportation of any such goods, and such person shall also deliver at the same time one or more duplicates of such bill, in which all sums and numbers may be expressed in figures, and the particulars contained in such bill shall be written and arranged in such form and manner as the collector and controller shall require, and thereupon the collector and controller shall cause a cocket to be written for such goods, making it known that such goods have been entered, and shall sign such cocket and deliver it to the person who shall have made such entry, and who shall keep and be responsible for the proper use of the same. Section 65. Before any part of the goods for which any cocket shall have been granted shall be shipped or waterborne, to be shipped, the same shall be duly cleared for shipment with the searcher, and before any goods be cleared for shipment, the particulars of the goods for each clearance shall be endorsed on such cocket, together with the number and denomination or description of the respective packages containing the same. And on the margin of such endorsement shall be delineated the respective marks and numbers of such packages, and to each such endorsement shall be subjoined in words at length an account of the total quantities of each sort of goods intended in such endorsement, and the total of each sort of package in which such goods are contained, distinguishing, etc. And all goods shipped or waterborne to be shipped, not being duly cleared as aforesaid, shall be forfeited. Section 70. The person clearing such goods for shipment shall upon each occasion produce the cocket so endorsed to the searcher, and shall also deliver a shipping bill, or copy of such endorsement, referring by names and date to the cocket upon which such endorsement is made, and shall obtain the order of the searcher for the shipment of such goods, which endorsement and shipping bill shall be written and arranged as the collector and controller shall require. Section 71. Before any ship shall be cleared outwards with goods on board, the master shall deliver a content of such ship to the searcher, setting forth the name and tonnage of such ship, and the place and places of her destination, and the name of the master, and also an account of the goods shipped on board, and of the packages containing such goods, and of the marks and numbers upon such packages, and also before the clearance of such ship, the cockets, with the endorsements and clearances thereon for the goods shipped, shall be finally delivered by the respective shippers of such goods to the searcher, who shall file the same together, and shall attach with a seal a label to the file, showing the number of cockets in the file, and shall compare the particulars of the goods in the cockets with the particulars of the goods in such content, and shall attest the correctness thereof by his signature on the label and on the content. And the master of the ship shall make and sign a declaration before the collector or controller to the truth of such content, and shall answer to the collector or controller such questions concerning the ship, the cargo, and the intended voyage, as shall be demanded of him. And thereupon the collector or controller shall clear such ship for her intended voyage, and shall notify such clearance and the date thereof upon the content, and upon the label to the file of cockets, and upon the victualling bill, and also in the book of ship's entries outwards, for the information of all parties interested, and shall transmit the content and the cockets and the victualling bill to the searcher. Section 78. The file of cockets and the victualling bill shall thereupon be delivered by the searcher to the master of such ship, and such file of cockets and victualling bill so delivered shall be kept by the master of such ship, as the authority for departing from the port, with the several parcels and packages of goods and of stores on board, so far as they shall agree with the particulars in the endorsements on such cockets, or with such victualling bill. Section 79. When the ship has arrived at the place of her destination, the master must take care that she be safely moored or anchored, and report his ship and crew, and deliver his manifest and other papers according to the law and customs of the place. By the same Act 3 and 4, William IV, Chapter 52, it is also enacted that no goods shall be unladen from any ship arriving from ports beyond the seas, at any port or place in the United Kingdom or the Isle of Man, nor shall bulk be broken after the arrival of such ship within 4 leagues of the coast, before due report of such ship and due entry of such goods shall have been made, and warrant granted in manner therein after directed, that no goods shall be unladen, except at such times and places, and in such manner, and by such persons, and under the care of such officers as is thereinafter directed, and that all goods not duly reported, or which shall be unladen contrary thereto, shall be forfeited. And if bulk be broken contrary thereto, the master of such ship shall forfeit £100. And if any alteration in the stowage be made to facilitate the unlading, or any part of the cargo be staved or destroyed, or any package opened within 4 leagues of the coast, the ship shall be deemed to have broken bulk. Section 2. That no goods shall be imported from parts beyond the seas in any British ship, nor any tobacco in any ship, unless the master shall have on board a manifest of such goods, or of such tobacco, made out and dated, and signed by him at the place where the same, or the different parts of the same, were taken on board, and every such manifest shall set forth the name and the tonnage of the ship, the name of the master, and of the place to which the ship belongs, and of the place or places for which they are destined respectively, and shall contain a particular account and description of all the packages with the marks, etc., and of such goods as are stowed loose, and the names of the respective shippers and consignees, as far as the same can be known to the master. A general account must be subjoined. Section 3. That before any ship shall be cleared out, or depart from any place in any of the British possessions abroad, or from any place in China, with any goods for the United Kingdom, or the Isle of Man, the master of such ship shall produce the manifest to the collector or controller of the customs, or other proper officer, who shall certify upon the same the date of the production thereof to him. Section 4. That if any goods shall be imported into the United Kingdom or into the Isle of Man without such manifest, or if any goods contained in such manifest be not on board, the master shall forfeit £100. And if he refuse to produce such manifest, and deliver a copy thereof to any officer of the customs, who within 4 leagues of the coast shall demand the same, he shall also forfeit £100. Sections 6 and 7. That the master of every ship arriving from any such ports beyond the seas shall, within 24 hours of such arrival, and before bulk broken, make due report of such ship, and make and subscribe a declaration of the truth of the same before the collector or controller of such port. And such report shall contain an account of the particular marks, numbers, and contents of all the different packages or parcels of goods on board, and the particulars of such goods as are stored loose, to the best of his knowledge, and of the place and places where such goods were respectively taken on board, and of the burthen of such ship, and of the country where such ship was built, or if British, of the port of registry, and of the country of the people to whom such ship belongs, and of the name and country of the person who was master during the voyage, and of the number of people by whom such ship was navigated, stating how many are subjects of the country to which such ship belongs, and how many are of some other country. And in such report it shall be further declared whether and in what cases such ship has broken bulk in the course of her voyage, and what part of the cargo, if any, is intended for importation at another port in the United Kingdom, and what part, if any, is prohibited to be imported, except to be warehoused for exportation only, and what part, if any, is intended for exportation in any such ship, to ports beyond the seas, and what surplus stores or stock remain on board such ship, and if a British ship, what foreign-made sails or cordage, not being standing or running rigging, are in use on board such ship, and the master of any ship who shall fail to make such report shall forfeit £100. Section 8. That the master of every ship shall, at the time of making such report, deliver to the collector or controller the manifest of the cargo, where a manifest is required, and if required, shall produce to him any bill or bills of lading, or a true copy thereof, for any and every part of the cargo, and shall truly answer all such questions relating to the ship and cargo, and crew, and voyage, as shall be put to him by such collector or controller. And in case of failure or refusal, or if such manifest or bill of lading or copy shall be false, or if any bill of lading be uttered by any master, and the goods expressed therein shall not have been bona fide shipped on board, or if any bill of lading uttered or produced by any master shall not have been signed by him, or any such copy shall not have been received or made by him, previously to his leaving the place where the goods expressed in such bill of lading or copy were shipped, such master shall forfeit £100. Section 11. That every ship shall come as quickly up to the proper place of mooring or unlading as the nature of the port will admit, and without touching at any other place, and in proceeding to such place shall bring to, at stations appointed by the commissioners of His Majesty's Customs, for the boarding of ships by the officers of the customs, and after arrival at such place of mooring or unlading, such ship shall not remove from such place, except directly to some other proper place, and with the knowledge of the proper officer of the customs, on penalty of £100, to be paid by the master of such ship. Section 13. Trouble there. Power to sell and hypothecate. The master has, in certain cases, power to hypothecate the ship and cargo, and also to sell a part of the cargo. And in certain extreme cases, a sale of the ship and cargo made from necessity, and in the utmost good faith, will be upheld. His right to do any of these acts is confined to cases of necessity, in distant ports, where he cannot get the advice of the owner. The safest rule for the master is to bear in mind that his duty is to prosecute the voyage, and that all his acts must be done for this purpose, and in good faith. If a necessity arises in a foreign port for the repairing or supplying of the ship, he must, in the first instance, make use of any property of the owner he may have under his control other than cargo. 3 Mason 255. If, however, he has money of the owner in his hands put on board for the purpose of procuring a cargo, he is not bound to apply this first, but must use his discretion, bearing in mind that all repairs have for their sole object the prosecution of the voyage, which might be defeated by making use of these funds. 3 Mason 255. His next recourse should be to the personal credit of the owner, by drawing bills or otherwise. 2 Wash C.C. 226. If these means fail, he is next to hypothecate, that is, pledge, the ship, bottomry, or cargo, respondentia, or freight, or sell part of the cargo, according to circumstances. If the owner of the ship is also owner of the cargo, the better opinion seems to be that the master may take whichever of these means can be adopted with the least sacrifice of the owner's interest, though probably selling part of the cargo would almost in all cases be the least favorable course for all the purposes of the voyage. 2 Wash C.C. 226. If the owner of the ship is not owner of the cargo, the master should bear in mind that he is agent of the former, and has generally no further control over the cargo than for safekeeping and transportation. 2 Washington C.C. 226. He should therefore first exhaust the credit of the ship and freight by hypothecation, and if these means fail, he then becomes, by necessity, agent for the owners of the cargo for the purposes of the voyage, and may hypothecate the whole, or sell a part, according to circumstances. As to selling part, he should remember that his duty is to carry forward the objects of the voyage, and that selling a large part would probably impair these objects more than hypothecating the whole. 3 Mason 255. 1 Wash C.C. 49. 2 Wash C.C. 226. 3 Rob 240. In no case can any of the cargo be sold or hypothecated to repair or supply the ship, unless these repairs and supplies are to be for the benefit of the cargo. The strictest proof is always required that the repairs were in the first place necessary, and, in the next place, that they were for the benefit of the cargo, and not merely for the good of the shipowner. 2 Wash 226, 3 Rob 240. A further question arises, whether the master has ever, and when, the right to sell the whole cargo and the ship itself. If it should be impossible to repair the ship and send her on the voyage by any of the means before mentioned, it then becomes the master's duty to forward the cargo to the port of destination by some other conveyance. If neither of these things can be done, then he becomes, from necessity, agent of the owner of the cargo, and must make the best disposition of it in his power. If the goods are perishable, the owner cannot be consulted within a reasonable time, and has no agent in the port, and something must be done with the cargo, and there is no one else to act. Then the master must dispose of it in such a way as best to subserve the interest of its owner. He should take the advice of the commercial agent or other suitable persons, should also use his own judgment and act with good faith, and take care to preserve evidence that he has done so. He has so done. If all these requisites are not complied with, he will incur the danger of having his acts set aside. 2 Wash C.C. 150. 3 Rob 240. The rule as to the sale of the ship is very nearly the same, except that it is, perhaps, still more strict. If all means for repairing the vessel and sending her on her voyage have failed, and a case of absolute necessity arises, the master may make sale of her. As a prudent man, he should have the sale made, if possible, under the authority of the judicial tribunals of the place. Even this will not, of itself, render the sale valid, but will go far towards sustaining it. He should consult the council, or other suitable persons, should have a survey made, should take care to have the sale conducted publicly and with the best faith in all parties, and to preserve evidence of the same. Although a person should buy in good faith, yet the sale will be set aside unless it can be shown that there was the strictest necessity for it. The master must not become a purchaser himself, and even if he afterwards buy of one who purchased at the sale, this transaction will be very narrowly watched, and he will be bound to show the very highest good faith in all parties. 5 Mason 465, 2 Sumner 206, Edwards 117. The strictness of these rules should not deter the master from acting, where the interest of all requires it, but will show him the risk that is run by acting otherwise than with prudence and entire honesty. He should remember, too, that in taking command of a vessel, he not only covenants that he will act honestly and with the best of his judgment, but also holds himself out as having a reasonable degree of skill and prudence. 1 Dallas 184. As to the safekeeping, transportation, and delivery of the cargo, the master's duties and obligations are those of a common carrier upon land. He is bound to the strictest diligence in commencing and prosecuting the voyage, a high degree of care, both of vessel and goods, and is held liable for all losses and injuries not occasioned by inevitable accident, or by the acts of public enemies. He is answerable also for unnecessary delays and deviations, and for the wrongful or negligent acts of all persons under his command. At the termination of the voyage, he must deliver the goods to the consignee or his agents. A landing upon the wharf is a sufficient delivery, if due notice be given to the parties who are to receive them. He is not, however, bound to deliver until the freight due is paid or secured to his satisfaction, as he has a lien upon the goods for his freight. But the consignee can require the goods to be taken from the hold, in order that he may examine them before paying freight. In such case they should not go out of the possession of the master or his agents. Power to sell and hypothecate in England. The law, as respects the authority of the master to sell or hypothecate the ship and cargo, is the same in England as in the United States. The master of a ship has not, unless in a case of extreme necessity, authority to sell the ship, and he is bound seriously and deliberately to try every other expedient before disposing of the ship or any part of the cargo. See Abbott on Shipping, 6th edition, section 597. For Campbell, 138. See also 1 Bing, 243, 3 Broad and Bing, 151, 8 Taunt, 755, 3 Broad and Bing, 147, 1 Bing, 445. The observations as to the keeping, transportation, and delivery of the cargo are equally applicable to the masters of British vessels. Deviation. The master must not deviate from the course of the voyage. By a deviation is meant technically any alteration of the risk insured against, without necessity or reasonable cause. It may be by departing from the regular and usual course of the voyage, or by any unusual and unnecessary delay. A deviation renders the insurance void, whether the loss of the vessel is caused by the deviation or not. It is not a deviation to make a port for repairs or supplies, if there be no unnecessary delay, nor to depart from the course of the voyage in order to succor persons in distress, to avoid an enemy, or the like. It is the master's duty, within 24 hours after arriving at his first port, to make a protest in case of any accident or loss happening to vessel or cargo. The logbook also should be carefully kept, without interlineations or erasures. The master must also enter a protest in case any American seaman is impressed, and transmit a copy of the same to the Secretary of State under a penalty of $100. Act 1796, Chapter 36, Section 5. Deviation in England. The first part of the observations under this head will apply to British ships. While a vessel is detained at a port of necessity, it seems to be no deviation to take in an additional cargo, if no additional delay or risk is occasioned thereby. Abbott on Shipping, 6th edition, 319. 9 East, 195. 11 East, 347. 12 East, 131. On the arrival of the vessel at her homeward port, and when compelled by accidents or injury to put back or into a port other than that of her destination, it is usual for the master to present himself before a notary and cause a protest to be noted, and afterwards drawn up or extended. British consuls at foreign ports are empowered by statute, 5 and 6 William IV, Chapter 62, Section 15, to perform notarial acts, but inasmuch as their attestation would probably not be deemed abroad of equal authenticity with that of the regular public notary, the master would do well to address himself to that functionary. With whatever formalities drawn up, this protest cannot be received in our courts as evidence for the master or his owners, but it may be evidence against him and them, and he should take care to supply from the logbook, his own recollection, and that of the mate, or trustworthy mariners, true and faithful instructions for its preparation. See Abbott on Shipping, 6th edition, 335, and cases there cited. Collision. A vessel having the wind free must make way for a vessel close hauled. The general practice is that when two vessels approach each other, both having a free or fair wind, the one with the starboard tacks aboard keeps on her course, or, if any change is made, she luffs, so as to pass to windward of the other, or, in other words, each vessel passes to the right. This rule should also govern vessels sailing on the wind and approaching each other, when it is doubtful which is to windward. But if the vessel on the larboard tack is so far to windward that if both persist in their course the other will strike her on the lee side, abaft the beam, or near the stern, in such case the vessel on the starboard tack must give way, as she can do so with less loss of time and greater facility than the other. These rules are particularly intended to govern vessels approaching each other under circumstances that prevent their course and movements being readily discerned with accuracy, as at night or in a fog. At other times, circumstances may render it expedient to depart from them. A steamer is considered as always sailing with a fair wind, and is bound to do whatever would be required of a vessel going free. Report of Benjamin Rich and others to District Court of Massachusetts. Collision in England. The master is bound to his owners for the exercise of reasonable skill and care in the management of the vessel, and he and they are bound in like manner to every one who is affected by his acts. Within the scope of his employment, he must, therefore, during the whole course of the voyage at sea, at anchor and in port, perhaps even when a licensed pilot is on board, be vigilant, to avoid the peril of collision. Abbott on Shipping, 6th edition, 200. 3 Hag ad Rep. 176. It is said that there are 4 possibilities under which collision may occur. In the first place, it may happen without blame, being imputable to either party, as where the loss is occasioned by a storm, or any other vis major. In that case, the misfortune must be borne by the party on whom it happens to light, the other not being responsible to him in any degree. Secondly, a misfortune of this kind may arise where both parties are to blame, where there has been want of due diligence, or of skill, on both sides. In such a case the rule of law is that the loss must be apportioned between them as having been occasioned by the fault of both of them. Thirdly, it may happen by the misconduct of the suffering party only, and then the rule is that the sufferer must bear his own burthen. Lastly, it may have been the fault of the ship which ran the other down, and in this case the innocent party would be entitled to an entire compensation from the other. 2 Dodd at Rep. 83. The established rules of nautical practice as explained by professional men, the usages and regulations of particular ports and rivers, the state of the wind, the tide, and the light, the degree of vigilance of the master and crew, and all other circumstances bearing upon the conduct and management of both vessels, will be considered in determining this question. But of the sea as of the road, the law recognizes no inflexible rule, the neglect of which by one party will dispense with the exercise of ordinary care and caution in the other. See Abbott on Shipping, 6th edition, 207, and cases there cited. In case of damage done by a foreign ship to any British ship, barge, boat, buoy, or beacon, such foreign ship may, by order of a judge, be arrested until the master, owner, or consignee undertake to appear and be defendant in any action brought for such loss or damage, and give security for all costs and damages which may be recovered in such action. 1 and 2 George IV, Chapter 75, Section 32. By a recent regulation of the Trinity Board, when two steam vessels meet and are in danger of collision, both vessels are required to put the helm a port. Pilot. The master must take a pilot when within the usual limits of the pilot's employment. 6 Rob 316, 7 TR 160. If he neglects or refuses so to do, he becomes liable to the owners, freighters, and insurers. If no pilot is at hand, he must make signals and wait a reasonable time. The master is to be justified in entering port without a pilot only by extreme necessity. After the pilot is on board, the master has no more control over the working of the ship until she is at anchor. 2B and add 380, 3 Kent's Com 175, C. Pilot in England. What is here said is applicable to British vessels. For the provisions relating to pilots and pilotage, see the Act 6 George IV, Chapter 125. Wages, advances, etc. The master has no lien upon the ship for his wages. 3 Mason 91, 11 Pet R 175. He is supposed to look to the personal responsibility of the owner. He has a lien on freight for wages, and also for his advances and necessary expenses incurred for the benefit of the ship. Ware 149, but see 5 Wend 314. He can sue an admiralty in personam, but not in rem. That is, he can sue the owner personally, but cannot hold the ship. It does not seem to be settled in the United States whether the master has a lien on the ship for advances made aboard for the benefit of the vessel. 3 Mason 255. In case of sickness, the master's right to be cured at the expense of the ship seems to be the same as that of the seaman. 1 Sumner 451. Wages, advances, etc. in England. The master can only sue the owners personally for his wages in a court of common law, but as he generally receives the freight and earnings of the ship, and may pay himself out of the money in his hands, he has not often occasion for the aid of a court of justice to obtain his right. Abbott on Shipping, 6th edition, 587. The master has no lien on the ship or freight for wages or disbursements. See 9 East, 426, 1 B&A, 575, Abbott on Shipping, 6th edition, 124, and cases there cited.